Welcome to the DLA Piper Canada White Collar Symposium. Today's session will focus on a topic near and dear to my heart, which is competition law or antitrust law. For those of you have seen our seminars in this area in other years, I've presented on different topics. This year we're doing things a little differently because we are bringing in colleagues from other outside of Canada that are in the area. It's my pleasure to introduce three partners. The competition or antitrust group at DLA Piper globally spans over 80 lawyers across the globe, and we work together on many different ventures. And in particular, in the Americas, we've been working together and having regular communications over the last year and a half, developing a group. Antitrust or competition law is a practice area that is becoming increasingly important. There's a lot of upheaval in some major jurisdictions, including the US and Canada, with changes in approach to enforcement. And one of the lessons that you draw from this area is that it's really important to understand what's happening elsewhere, but it's also important to know because the enforcers coordinate. And if you have matters that you think are limited to your jurisdiction, you may find that they have impact elsewhere, and other enforcers may know. It's important to have a team who are in touch with one another and are able to effectively handle and guide you through it. Now, today's speakers, you have myself leading the discussion. I'm based in the Vancouver office in Canada. We have Brian Boyle, who's a partner in the Philadelphia office, who will be speaking to U.S. developments. We have Antonio Cárdenas Arriola, who is in Mexico City, partner in Mexico City. And then finally, but not least, we have Maria Claudia Martínez Beltrán, who's in our Bogotá, Colombia office. Frankly, we could have stacked this discussion with many other lawyers. We have representation through most of the largest countries in the Americas. We have, for example, in South America, significant practices in Brazil, Argentina, and Chile, for example. Today's focus, though, will be on the countries we've identified, and the way we're going to do this is I'm going to lead off a discussion about Canada, and then Brian, Antonio, and Maria will each talk about key developments in their jurisdiction, and then we're going to have some Q&A, just talking about various topics of relevance across the different matters. So I'll talk about now developments in Canada, and I'm going to focus on amendments, and I say amendments and more amendments. So Canada's had competition laws going back to 1889, and one of the chronic themes of Canadian competition law is that we've always seemed to be trying to self-discover, amending, rethinking, retooling. The last major restructuring took place in the mid-1980s. There was some significant amendments that took place around 2009, 2010. But since then, things have been relatively quiet until about last year, 2022. And at that point, the government announced that they plan to significantly revisit the Competition Act. And that's led to a whole slew of activity that's ongoing. And so we'll try to take a snapshot of where we are. So what happened is the government announces the amendments will be taking place, and they'll be looking at potential amendments in February of 2022. And I say the government, we have as our enforcement agency the Competition Bureau. Now, the Bureau itself enforces the law. They don't make the law. So some agencies in other jurisdictions, like the FTC in the US, have some rulemaking ability. The Bureau doesn't have that. So the Bureau is, although they're part of the Department of Industry in Canada, they are essentially autonomous, and the government itself will be deciding what legislation to put forth. That said, the Bureau will have a significant voice and has been very vocal in expressing what it thinks are the priorities for changes to the law. And we've seen these going hand in hand. So what happened is that we saw an initial round of amendments that were tabled in April of 2022 in connection with a budget implementation process. There was very little debate about those amendments because of the way they were introduced as part of a budget. and they came to be passed into law in June 2022, except for one provision I'll talk about in a moment that was delayed in implementation. So then what happened it was in November of last year, 2022, almost a year ago, a white paper was tabled by the government outlining topics for a consultation for potential further amendments. They saw the initial 2022 amendments as sort of a down payment on things to come. And what followed then was a process where many submissions were made. I think the closing period for submissions was the end of March of 2023 this year. They had over 130 submissions, including from the Bureau itself. The Bureau's publication recommended over 50 changes to the law, which are just staggering. This is much more than incremental change. It's even more than the changes that we saw in 2010, which themselves were significant. So there's a lot really on the table. And that's in addition to the changes already made. And then in June of this year, one of the provisions from 2022 that was introduced, that is the criminalization of no-poach agreements and wage fixing agreements between employers, it came into effect. The delay was made really to give businesses, employers an opportunity to consider the implications of the law, because there would not really be any grandfathering of old agreements. So they put that in. The Bureau issued guidelines on how they would approach the law. We now have criminalization on the books of those provisions now. And then what's the next step? Well, not only last month in September, the government did two things. First of all, they gave us an update on the review of all those submissions they've been busy reading since the end of March. And they made some general observations about how they saw there was quite diverse submissions made. There was obviously some people who were very much in favor of significantly changing the law or overhauling how we do things, and there were some reactions to saying no, the law is more or less okay as it is, or the changes should be much more measured. And so the government synthesized those, but really the signal that came out of that report was, yes, they are going to be coming up with other changes, at least to propose for discussion. And that's being reinforced by subsequent speeches by the minister, Champagne, who spoke, for example, on the Bureau Competition Day earlier in October. So we know something's going to happen. We don't know exactly what. But one thing that has happened, again, in the short term, is in mid-September, the government tabled what's come known as Bill C-56, and it's proposed 3 additional amendments, and I'm going to talk a little bit about those today. Now, these is still at the discussion stage. They've now gone through second reading. There's been some debates on the law, and we'll talk a bit about those today. But the lesson that comes from Canada is that it's still very much fluid. And that we will expect probably a lot more changes to be tabled either at the end of this year or perhaps into 2024. So I've talked now a bit about what Bill C-56 involves. And the context for this is the first bill of the latest session of Parliament. And so while it's not quite a budget bills like the last time in 2022, they're infamous for being types of legislation that aren't really open to debate because they're matters of competence. And while Bill C-56 isn't of that nature, because it's being featured by the government, I expect that we will. If you're betting, I think you bet that the government's going to want to see this passed, and they ostensibly discussed the bill as trying to address issues about rising grocery prices. That's been a sensitive issue in the country. The grocery sector has led to a lot of attention, even going back to the wage fixing law. There was a parliamentary process relating to certain premiums that had been initially offered to workers during the pandemic that were taken away by 3 major grocery chains within a very short span. Yeah, and the parliamentary the committee held sessions interviewing the executives from the various grocery chains, and it turned out that they had communications at or about the time the amendments were made, the amendments to take away the premiums were made. So that well, there was debate about whether that was an agreement or not. Certainly, it got Parliament's attention. They decided they wanted to criminalize it. So groceries still seem to be in the headlines, and as we deal with general inflationary pressures. And one thing that struck me is that although they've used that as a justification for this bill, nothing in the bill is specific to the grocery sector, and it seems a little unlikely that or more than unlikely that the bill itself is likely to have any impact in the short run or even the long run on grocery prices. But that said, it is what it is, and let's talk about what's happening. The First Amendment is that they're going to eliminate what's known as the efficiencies defense for mergers. Now, mergers is one of the major areas where the Competition Act engages, and eventually it says anytime you have a merger, the acquisition of a significant interest in a business of another in Canada, that there's a chance for it to be challenged by the Competition Bureau on the basis that the merger is likely to lessen or prevent competition substantially. The Bureau can challenge mergers before they take place. They can seek to block them in those situations if they want. They also can challenge it up for 1 year after closing. So it's an important gateway. Most mergers don't get challenged, but the ones that do can lead to a lot of controversy. And we've seen some large mergers that have been the subject of litigation, perhaps more litigation than normal in Canada. So one of the issues that's come up is this defense, which essentially says even if you have a merger that is otherwise anti-competitive, that lessens or prevents competition substantially, the merger might be saved if the parties are able to show that there are efficiencies and that the gains from efficiencies that accrued to merger that wouldn't have happened if you didn't have an order made against the merger under the Act, that those efficiencies would outweigh the anti-competitive effects. And there's a lot of law about actually how you would make that work, but the thinking behind the law when it was first put in was to promote efficiency in the economy and recognize that as a smaller economy, there may be situations where it's better to have a more robust enforcement, more robust, I mean, mergers that can go forward even if they have efficiencies, even if there's an expensive competition. That's led to a lot of controversy, and the decision that's being made now is to take it out, although it's a bit surprising because there's other provisions in the Act dealing with competitor collaborations that still have an efficiencies defensive sort. So we don't quite know what the role would be left for efficiencies, and we might find that through the further amendment process. And there's a period when this will take effect. It'll basically take effect only after the legislation is passed, and mergers that were filed beforehand will still be able to take advantage of the defense. Now, there's also an ability for the Bureau to conduct market studies. The Bureau has conducted market studies before, but they haven't had a formal power. It's been the subject of some controversy. The main change now is that the Bureau will have the formal ability to go to get court orders to compel information, documents information. The market studies themselves will be initiated on the direction of the minister. So the minister essentially will tell the Bureau, and it could be on advice from the Bureau, but the minister will be the gatekeeper as to whether the study takes place. Now, this will impose a lot of costs if you are caught up in one of these, because it can be very costly to respond to these orders asking for documents or information that could include examining people under oath. So that's a big change that the Bureau is pressing for. They now have. And of course, what they get in the market studies, in terms of, you think about forward enforcement, although a market study isn't about enforcing the law, it's not about alleging a violation. If they find anything that gives rise to a potential violation, that they can use that information going forward. So stay tuned on that. And then the final change on this law was to expand the civil conspiracy provision and to allow for orders to be made to block the implementation and enforcement of anti-competitive agreements between two persons where a significant purpose of the agreement arrangement is to prevent or lessen competition in any market. And so what's this all about? Well, the civil conspiracy provision essentially deals with things like joint ventures, strategic alliances, where you have two or more competitors that have engaged in what's otherwise a lawful process, but might have features that lessen or prevent competition. And if it lessens or prevents competition substantially, an order can be made essentially blocking enforcement. It's not a situation where people get penalized through fines or jail. And what the concern that came up was this, is that there could be situations where there's an agreement. For example, it could be in, let's say, the grocery context, a shopping center where you have a lease that has a restrictive covenant that restricts the use of a facility for certain purposes. So you could have an anchor tenant that says, say you're a grocery store, I don't want any other grocery stores there. Or you could have a restrictive covenant that goes on title saying, if I sell, I don't want this to be replaced by a grocery store because I'm setting up a new store next door and I don't want competition. So the thinking there is that it's going to give more flexibility. The takeaway will be this: for if you're in business, it's just going to open up drastically the amount of restrictive covenants that could come under the review of the act. And we'll have more to later on what to do practically to measure that. So that's a high level of what's happening in Canada. I'm not going to turn over to Brian to talk about US developments.
Thanks so much, Kevin, and greetings everyone from New York. As Kevin said, I'm Brian Boyle. I'm a partner in our U.S. antitrust practice, and there has been quite a bit of recent development in the U.S. In this area. It's become quite a dynamic area of law, and as I've said to many people recently, has gone from being sort of a niche interest of lawyers like those of us on the call today to something that we read about on the front page of the Wall Street Journal every day. So certainly something that has increased in importance as a risk for a lot of our clients in a wide array of different industries. Today, I'm going to focus on kind of a small subset of issues, given the focus of this conference. I'm going to focus on primarily criminal enforcement of the antitrust laws and what trends we're seeing there. And in particular, I'm going to talk about some things that, given these trends, given the focus of the agencies and the DOJ in particular, some things that you can watch out for in your businesses. So overall, kind of what are the trends that we're seeing in U.S. criminal enforcement and cartel enforcement? The headline, frankly, is that overall, recently we've seen fewer major, large-scale cartel cases, fewer kind of big international cartels, right? And that has resulted in the government collecting fewer fines. Certainly in 2022, last year was one of the lowest numbers in many years. Instead, what we've seen is a lot more emphasis on a couple of different areas. One being government contract bid rigging cases. So, and I'll talk a lot more about this, but there's a tremendous focus in the U.S. on bid rigging conduct generally and government procurement specifically. And it's something that really any company that has or is considering any kind of business with a federal government customer, but also a state or local government customer in the U.S. Really needs to pay close attention to. We've also seen a lot more focus on what I'll call novel theories, which are frankly cases that in years past would not have been prosecuted criminally, or frankly not at all. But the antitrust division has recently decided to try to prosecute them criminally. And I'll talk a little bit more in a second about what some of those areas are. I think important to understand, though, that when I say that we've seen fewer major cartel cases, that in no way should sort of be interpreted to mean that risk is lower, or that that's going to be the trend going forward. In spite of the sort of decrease in these big headline grabbing cartel cases, there is undoubtedly a very aggressive enforcement posture. And we know that both from sort of our informal discussions with individuals in the antitrust division and sort of what we're seeing through public data, that they continue to act very, very aggressively in this space. So we know that there are quite a few active grand jury probes. At the end of last year, in fact, it was a 30-year high, which means that they are actively investigating a very large number of cases that they believe may involve criminal conduct. The division still has a very active trial calendar. They're bringing cases. And I think, you know, a takeaway there is, frankly, that over the next couple of years, you should expect to see a significant uptick in large-scale criminal cartel prosecutions in the United States. All of the work that the division is putting in now is intended to lay the groundwork for cases that will come, and that's something that everybody should, you know, frankly have the eyes wide open about. You know, I touched a minute ago on some of the non-traditional cases, and I want to pause there for a minute because I think that that's important too. You know, and a trend we've seen, frankly, across antitrust enforcement in the U.S. on both the civil and the criminal side is the agencies bringing what I would bringing enforcement and initiating investigations in cases that I would call sort of on the margin of antitrust conduct. So certainly on the civil side, we see them investigating conduct that, you know, would not be typically thought of in the U.S. as necessarily violating the antitrust laws, or, you know, would be it'd be a tough, you know, sort of a close call whether it might violate the antitrust laws. So, for example, this can include and has included a lot more scrutiny of information sharing conduct. So even in cases where there's no anti-competitive agreement, much more scrutiny of information exchange between companies. And on the criminal side, it has included prosecuting cases criminally that in recent years would have been treated as a civil matter. And I want to highlight two areas in particular. So the first is one that you've probably heard a great deal about, and that is labor market cases. So wage fixing and no poach cases. And this kind of fits in with Kevin's comments a minute ago about Canada criminalizing some of this conduct. Back in 2016, the Department of Justice issued guidance. It's guidance for human resources professionals, saying that it would begin to treat naked agreements between competing employers not to poach one another's employees or to fix wages as a per se violation of the antitrust laws here in the U.S. and as a criminal offense. If you could go back to the prior slide for a minute, please. And there was a number of years where, you know, that generated a lot of talk, but not a lot of prosecutions. Well, in the past couple of years, the Department of Justice has brought a number of these cases. So far, they've been largely unsuccessful. They've, in fact, you know, they've accumulated a string of losses in these cases, but they've been quite clear that they intend to keep prosecuting these cases criminally, and so that remains something that's very important to watch out for. Another area has been that the Antitrust Division, for the first time in about 45 years, has prosecuted monopolization cases, or what would be referred to in a lot of other jurisdictions as abuse of dominance cases, criminally. And, you know, in the cases where that has happened, they have been fairly extreme cases of conduct, but they certainly signal an increased focus on monopolization issues, and I think are a signal for any companies that are thinking about U.S. antitrust compliance to make sure that they don't gloss over that area, and that they give careful consideration to where they might be dominant and how they approach their conduct in those markets. Have the next slide, please. So as I touched on a minute ago, a huge emphasis right now in the U.S. is bid rigging, and in particular bid rigging in contracts with government customers. And the Antitrust Division has created a dedicated unit called the Procurement Collusion Strike Force that's focused on this. And they've done a number of things that are innovative and I think important for companies to understand from a compliance perspective. The first is that they've conducted a tremendous amount of training for government procurement officers at all levels of government in the United States. So federal government, state governments, local governments. They've gone out and they're essentially training these people to look for indicators of fraud, indicators of bid rigging conduct. They're also using, and this extends sort of even beyond the strike force itself, the Antitrust Division generally has invested significantly in using data analysis techniques. They've hired data scientists. They're using new artificial intelligence techniques to examine patterns of bidding behavior and look for evidence of bid rigging. And that's really important because that means that that enables the antitrust division to potentially proceed quite far in an investigation before the companies involved in the investigation have any indication that they're being investigated. And so to me, an obvious practical implication of that is that if your business is engaged in contracting, it's critically important that you be just as proactive as the government and make sure that you're taking a really thoughtful and careful approach to monitoring and auditing those business functions. I'll also just say quickly that that is something it's something that affects not only bidding for business sort of within the U.S. itself, but it's also the Justice Department has been very clear, and they've brought cases involving government bids by companies outside of the United States. And so, you should think about if you have business at a U.S. military base, at a U.S. embassy around the world, sort of anything that might affect a government purchaser, you may well be on the radar here. And the last point I'll make here is what you see on the right-hand side. This is not a black box. There are sort of patterns of behavior, there are market characteristics that companies can look for to conduct some of the same analysis that the government will conduct and be proactive. So this is something that on the one hand is a significant risk area, but on the other hand is something that can effectively be managed through proactive steps. And of course, be happy to talk about that further later in my remarks.
Thank you very much, Brian. I'll move on to Antonio.
Thank you, Kevin. Greetings to all. I'm very pleased to be here. I am Antonio Cárdenas from Mexico City office. I'm a partner from Mexico City office and antitrust. And first, I wanna introduce you to the Mexican Antitrust Commission, which is an autonomous by a constitutional provisions. It's an autonomous agency. It's independent from the executive branch of the government. It's important to say that it was done in order to preserve the high level of technical skills of this type of organs, and to avoid the intrusion of political decisions in the decisions regarding the competition in Mexico, as it was happening before this reform in 2013, where the defunct Antitrust Commission depended on the Ministry of Economy of the executive branch. This is important because two things. It's in Mexico, it doesn't exist the private enforcement of the competition law. So it's in order to have a review of the exercise of the enforcement of the competition law, we have two agencies. One is the Antitrust Commission, which oversees practically everything about of competition, except telecommunications. The telecommunications sector in Mexico is a hyper-concentrated one. It's one case of a study. We have a huge company here, América Móvil, and it needed a special agency to regulate that sector. But right now we are going to focus in the Antitrust Commission, the other one. And the first trend and development I want to stress here is the energy sector. This current administration, López Obrador administration, for ideological positions and for historical reasons, have a great focus in the energy sector. And through several reforms of the incumbent party of the president, there was a damage in several markets in energy. For example, one of the most significant ones is the electricity sector. in which through these reforms since 3 years ago, the government is trying to convert the Federal Electricity Commission in a national champion. Of course, it has a lot of problems in the market because you have a public entity, a national champion in charge of producing and selling around of 60% of the electricity in Mexico. And the Antitrust Commission issued several opinions against that because, of course, it translates in several issues in the market. For example, these reforms forbid the possibility for the private generators to participate in a energy bid for the companies and produce and sell clean energies for the market. And as we know by now, for the nearshoring, for the growing of Mexican economy, the demand of electricity is great. So these provisions are very harming to the market. It's important to say that right now it's under an scrutiny in the judicial branch for the constitutionality of the Ley de la Industria Eléctrica, electric industry law, which was very opposed against by the Antitrust Commission. The other important investigations or trends in the energy sector is several investigations of the Antitrust Commission in the LP gas sector at the jet fuel market in Mexico. It's important. LP gas, it's a very important one because LP gas is one of the primary energy sources for Mexicans, especially for poor Mexicans. So it's a very delicate market, and the Antitrust Commission issued a resolution last year where they accrued the highest fine in history for alleged cartelization between several economic agents in the market. The other one that I want to stress is the other markets that are right now trends for antitrust in Mexico right now. It's, for example, the technology sector, and it's following a global trend. As you may know, there is several prosecutions in several jurisdictions against technology producers, basically mobile devices, and producers of app producers and the browsers. For example, the cases of Google and Facebook, Meta. The other trend, it's important and impacts highly in the market, is the lithium. This current administration are trying to monopolize the lithium through a state company. And of course, it will affect several possible concessions for mining companies. For example, yesterday we have this struggle with a Chinese company who was granted a concession on mining lithium. But again, this current administration is trying to not acknowledge all the efficiencies that you can have with the private competitors, and again it's an important desire to create another national champion. Of course, the market of lithium, Mexico has one of the biggest reserves on lithium in the earth, and right now we are trying to exploit that through an state company, which of course will have several problems with the competition, since the government, since that eliminates the efficiencies of a competitive market. The other trend, it's important, I want to stress, is that it's a high amount, as Brian was saying, it's a high degree of cooperation between agencies. Mexican Antitrust Commission. It's really good related with some other agencies, and they are focus efforts on joint investigations. For example, the joint communication of the antitrust commissions, antitrust agencies in Canada, US, and Mexico regarding the next World Cup. And finally, I will stress the political struggle. The current administration doesn't like the autonomous agencies in some way by the things I already said, the opposition to this new electricity regime that eliminates efficiencies and even produces a lack of competition in the market. So the current administration has a very harsh relationship with the antitrust agencies. And next slide, very quick. Next slide, please.
Sorry, I'm trying to.
Oh, no problem.
Yeah. Okay.
Yeah, corruption. As Brian also mentioned, it's important to say that in our experience, we see a great connection with corruption in biddings and corruption with public entities and cartelization, the possibility of cartelization. And we are right now having a huge case of corruption that in my opinion, we will have a lot of issues from it. It's Segalmex is a public entity in charge of ensure the food security and improving the welfare of small-scale farmers. There is a huge scheme. Right now, it's in the ABAC side, in the anti-bribery side of investigation with the Mexican equivalent to DOJ, the Fiscalía General de la República. It's a scheme of about $500 million, but some estimates say that it could arise to $1 billion. And why is important? Because it's very likely that regarding this umbrella of corruption of Segalmex, it's this big public entity, it's a possible cartelization of vendors in this operation. So in the years to come, my opinion, we will know about more of this case regarding the antitrust issues, specifically in the cartelization side. As in the US, it's a per se practice, and it's very, very harsh prosecuted by the antitrust agencies and even with the criminal side. And that's it. I will pass the word to María Claudia from Colombia, and thank you very much.
Okay, María Claudia, over to you.
Thank you, Kevin. Thank you for the invitation. Thank you also to DLA Piper Canada for having us here. It's great to address you and let you know more about the Colombian competition regime and its relationship with criminal compliance. There's really I would say the most important thing that relates in the relation between competition law and criminal corporate compliance is bid rigging, right? Because this is the only anti-competitive act that it's also actually a criminal offense in Colombia. And what has happened in Colombia, we have, so you also understand like in general about our regime. We have an competition regime since 1959. It's one of the oldest regimes in the region in Latin America. And it has been obviously modified. And in 2009, there was this huge reform to the competition regime, which led to start different investigations by the competition authority, which is actually an administrative authority that belongs to the executive branch, but it's supposed to be independent. So what has happened? since 2009, a lot of investigations were open and companies really started to comply with the competition regime because the fines increased. That was the major reason. So since the fines increased, the competition authority started investigating, and we had a lot of investigations regarding cartels, regarding abuse of dominant position, no bid rigging at that moment. And then the superintendents of industry and commerce, which is the competition authority, actually relaxed and just focused on bid rigging cases. And for the last 4 years, I would say, their main issue, their main investigations are all related to bid rigging. But we changed government last year, and also the head of the superintendents changed. And this new superintendent has started to reactivate the enforcement on anti-competitive cartels. They have an open investigation for no-poach agreements in the sports sector, specifically in the women's professional sports sector. Also, they have open investigation of abuse of dominant position in the telecommunications sector. They have started to move a lot and started opening investigations different than bid rigging, but they still have the bid rigging specificities and as a principal matter. Why? Because, as I mentioned, it's the only criminal offense that is also an anti-competitive behavior. And also because the superintendents decided in 2017 to have this specific group of employees or professional investigators just to investigate bid rigging. They have the same number of public officials or public officers that investigate all the rest of the anti-competitive behaviors that also address just bid rigging. So it's a really important issue and matter here for the competition authority. And as I mentioned, it's so important that they investigate all sectors. It doesn't matter if there's no de minimis rule. It doesn't matter if it's a small bid or procurement process. It doesn't matter if it's huge, and they have sanctioned in all types of bid rigging, as I said. Also, they initiated gun jumping investigations, which they hadn't done in a few years. So all merger control is also being a part of this new competition authority. That it's being something that it's important, and they're starting also to investigate companies for gun jumping, which, as I mentioned, wasn't happening in the last years. Next slide, please. So what is important to consider for bid rigging? So as I mentioned, the competition authority, which is the superintendents of industry and commerce, has an elite group that just focuses on bid rigging cases. So they open in a month, they can open 5 investigations for bid rigging, because as I mentioned, they can open investigations to really small companies or to big companies. It doesn't matter. What they do, since this is also a criminal offense, they send all the documents and evidence of the investigation to the general attorney's office, which is the entity that investigates criminal offenses. But in Colombia, what we have is just criminal offenses can be done just by individuals. So in the end, companies were never going to be investigated from a criminal offense point of view, right? Just the individuals that were involved in the bid rigging investigation. So the superintendents of industry and commerce, which is the competition authority, investigates, and they actually issue an administrative sanction against the company and the individuals. And after that, normally what is happening is that the General Attorney's Office is going to also investigate the individuals involved in the bid rigging, and if they, from a criminal perspective, find that they actually were involved in the criminal offense, then they could get imprisoned for up to 12 years. But what happened last year? Last year, in 2022, the Congress issued a modification of the anti-corruption statute here in Colombia. What happened there? The Congress said, okay, first of all, I'm going to modify the sanctions for anti-competitive practices. The sanctions are still around $30 million US dollars maximum, and they changed it and said, okay, we're going to let the superintendents of industry and commerce to sanction for up to 20% of the assets of the company. So the difference in the change in the sanctions were huge, right? And for companies, that $30 million were nothing, let's say. Like right now, the sanctions that could be imposed were not a number maximum, but it was related to their assets. So that's a higher risk, right? But the Constitutional Court decided that those articles were unconstitutional, and they removed them from the modification of the anti-corruption statute because they didn't, it was because of formalities. But this is something that is going to happen in Colombia. But also what happened last year with Law 2195, which is the modification of the Colombian anti-corruption statute, the Congress also said, okay, if a company that cannot be criminally liable because in Colombia there's only criminal liability for individuals, if by any chance they actually benefited from the criminal offense made by the individual, then they are also going to be investigated from an administrative point of view. But that's the relationship or the way that Colombia decided to have a criminal corporation liability, right? And so what can happen is that the superintendents of industry and commerce investigates from an anti-competitive regime point of view, they get sanctioned. Then the individuals involved in the bid rigging case can get investigated and imprisoned by the General Attorney's Office. And if the company benefited from the offenses made by the individuals, then it can be sanctioned again by another superintendents, which is the superintendents of companies, and can be, like I said, sanctioned again. And also they can prohibit that company to participate in public procurement for up to 20 years. So this is something that is really important that is happening here in Colombia in bid rigging cases, because it's like a wheel that goes and goes and never ends. And additionally, in Colombia, we have also class actions. So from a private sector, the competition regime can also be enforced. Thank you.
Thank you very much, Maria. Claudia. It's I guess bid rigging seems to be endemic everywhere. Of course, we have the same issue in Canada. We've had corporate liability and individual liability for many years. We don't even have a statute of limitations. So we've seen some recent convictions or charges laid in respect of conduct that took place before 2010, like over 13 years ago. And just yesterday there were some new charges in the infrastructure sphere laid against two individuals. So and Antonio, as in Mexico, it seems that often there's a high link between corruption investigations and antitrust. We had some major corruption investigations in the Quebec construction sector that spun off lots of bid rigging and antitrust cases. So just we have time for some questions before we're up to the top of the hour. I was going to come back to you, Brian, and ask this. So you've done a masterful job of synthesizing in a very short time the trends in the U.S. law. And I'm just wondering, given the changes in the US under the Biden administration, how does that affect what you think companies should be doing when they manage antitrust and other risks?
It's a great question, Kevin, and my answer sounds a lot better if I unmute myself. So, look, I mean, I think there are wide-ranging implications. I mean, one is at the highest level, and I think there is fairly wide recognition of this. The fact that the enforcement environment is so active and less predictable in the past because of many of the changes that have been implemented, which some of which I talked about, right? In enforcement of issues and in ways that would not have been the case in the past. I would suggest that antitrust generally should be something that is sort of, when you're for in-house counsel that are trying to assess sort of a hierarchy of potential risk sources, it's something that deserves maybe a closer look that it's gotten in the past, and for many companies will be a higher risk than it was in the past. But at a more detailed level, or a more sort of tactical level from in-house counsel, I do think that the changes we've seen suggest a couple of maybe changes in approach that may be appropriate for a lot of different companies. I mean, one is that to some extent, the trends that we've seen change the types of risks that companies need to be looking for, right? So, it's not just all about sort of traditional price fixing or traditional bid rigging anymore. We didn't have a lot of time to talk about this, but they need to be on the lookout for issues today like algorithmic collusion, right? Are you using pricing algorithms in your business? Certainly labor market collusion, as we touched on. And another issue that I mentioned, invitations to collude, right? So what types of communication, even if you're not engaged in price fixing or engaged in market allocation, what types of communications are happening, between your employees and competitors, and is there a risk of invitations to collude? So there's sort of this new category of issues that may not have been on the radar before, and may or may not be kind of captured by existing compliance procedures. And I also think that there are implications for the tools and strategies that in-house counsel use to detect risk. So, as I talked about, the government is leveraging data analysis and artificial intelligence. I think for many companies, you should be doing that too. A selfless plug, I think DLA has some of the best capabilities in that regard in the market in terms of our proprietary artificial intelligence tools that we can use for helping to detect cartel risk. But really, kind of however you're going to do it, it's important that you be as proactive and as creative in using technology as the enforcers are. And I think the last comment I'll make is I think the changes also mean that you have to look in different places for antitrust risk. So, historically, we've always kind of focused on sales and pricing functions within companies. It always seemed to be the sales folks that get into antitrust trouble. But today you have to cast the net more broadly than that. So you need to be considering HR, right? Are your HR teams adequately trained up on antitrust, and are you monitoring what information they might be exchanging with competitors? You need to be thinking about product development, right? And more, right? So I think it's also a broader scope of the areas of your organization that you need to account for.
Right. And Antonio, I'm just going to switch gears for a bit. We've heard from both Brian and I about the influence of the politics in our countries on the need to press change or the priorities for enforcement. I'm wondering about Mexico. Is politics playing in to your competition regime?
Yes, unfortunately, yes, Kevin. As we mentioned in the presentation, there is a political struggle right now between this high technical skills agency, a globally priced agency that we have. It's competition, the Antitrust Commission, and the current regime. And it's very likely that the next year Mexico will have elections as the U.S. And if the tendency confirms we will have the same political party, ruling political party, the political party of López Obrador, which has these political visions of maybe the late 70s, Mexico of the late 70s, very nationalist. And he's as I mentioned, he doesn't like the autonomous regulators in government. And it's possible the next administration will try, one, to continue these political decisions that may affect Canadian business. For example, concession title holders such as mining, such as railroads or infrastructure concessions of Canadian companies can be affected in the next administration. And the opposition, or the level of opposition, a technical opposition, because again, the arguments of the Antitrust Commission are an economic and a market arguments against that political decisions may not be heard, as happened with the electricity sector, that we need to judicialize that decisions. It's a real possibility. And the other one, it's maybe the next administration could retake this early proposition of President López Obrador at the very initial of his administration, which is even disappear the constitutional autonomous agencies, which of course will be a terrible backward for antitrust, for competition sector in Mexico, and against U.S.-Mexico-Canada treaty, in my opinion.
Okay, so we're almost at the top of the hour, and maybe I'm going to put a final question out to all three of you. So this is a Canadian-hosted symposium where we're thankful to have the perspective of everyone. So can you just think about your own jurisdiction, about what are some lessons that or guidance that you would offer to Canadian companies that might be doing business in, or might have an eye towards what's happening in your jurisdiction? I'll leave it open to fight for who wants to answer that first.
Well, I'll go first very quickly, to maybe make 2 points. One that Antonio made earlier, which is the antitrust and competition agencies in all of our countries are highly coordinated. And I think it's critically important that you take you being, any of the folks on the call here, take an equally coordinated approach to antitrust and competition issues across the Americas. The agencies talk to each other, and in the private enforcement world, there's, everyone's watching what's happening in other jurisdictions. And so I would encourage everyone to not approach antitrust and competition in the Americas as sort of a country by country issue, but instead look at it holistically and think about solutions that way.
Yes, and my view here will be, Kevin, that we need to focus, the Canadian companies need to focus in compliance. It's very important if they engage with relationships with the government to review their compliance, all the internal controls, and to make a safe and a good awareness of the antitrust issues.
I completely agree. And in 30 seconds, I would just add to what my colleagues just mentioned, is that to have a good compliance program, you need to understand the regime. And you really need local advisors to understand which are your risks. Like you don't know your risks sitting in Canada. You really need someone there to understand which the regime you have to comply with and prevent any risk.
That's a wise word. So I think on those comments, we'll end our session. I want to thank everyone in the audience. Feel free to reach out to any of us if you have questions. And we look forward to speaking with you over the next year. And of course, we'll be back again one way or the other for next year's symposium. Thank you very much.